Adjudication is an alternative dispute resolution mechanism where an independent party seeks to give an independent decision on disputes under a contract. Adjudication provides several benefits to the parties under the contract. It allows for a quick and expedient way of resolving disputes which become binding but not final until maybe overturned at a later date. It allows a project to continue being implemented even as disputes arise.
Do we have a law regulating adjudication in Uganda?
Uganda does not have a specific law that regulates adjudication. There are three main types of adjudication. You may have contractual adjudication, statutory adjudication. Third one, which is ad hoc adjudication.
In your experience, what are the common construction disputes that are referred to adjudication?
Disputes in construction are mostly about cash flow. There's also disputes over time, who is responsible for delays on the project, disputes over variation, common disputes over termination, over unforeseeable site conditions, the contractual balance of risk and liability, interpretation of the contractual terms. The FIDIC form of contract provides a more elaborate method for the dispute resolution, the middle one being adjudication. So it is mandatory. Under the FIDIC form of contract, adjudicators may be appointed by agreement between the parties. The conditions of contract would have provided for a list of persons to be adopted as adjudicators. Under the PPDA, the parties propose their adjudicators, and if these adjudicators are not agreed, then it's also referred to an adjudicating nominating body. When the parties fail to adhere to the timeline within which adjudication can be commenced, under the FIDIC, the notice of adjudication lapses. Same thing with under the PPDA, if a decision has been made by the project manager and the decision is not referred to adjudication, then the decision of the project manager becomes final and binding. Once the adjudicator does not make his decision within the specific timeline, then the referral is deemed to have been rejected.
Yeah, the whole adjudication process, that is,
yes,
is dead in the water.
So it's important that the adjudicators stick within the timeline.
A party is aggrieved by an adjudication decision. What immediate steps should be taken by that party, both under FIDIC and PPDA?
Once the party is aggrieved by the adjudication decision, they have a short window within which to make a decision on whether they're going to formally disagree, and this formal disagreement is by notice of dissatisfaction. So one party, who is the aggrieved party, issues a notice of dissatisfaction to the other party, indicating their disagreement with the adjudicator's decision.
If a party fails to take those necessary steps you've talked about, what happens?
The decision from the adjudicator becomes final and binding.
So this is what makes the change from the interim and binding nature of an adjudicator's decision to final and binding.
In Africa, statutory adjudication is not prevalent. What is the scope of construction contract covered by the Construction Act?
Statutory adjudication was born in the United Kingdom, and it has since been adopted by countries such as Australia, Singapore, Malaysia.
Is adjudication mandatory under the Construction Act?
Yes. The requirement is that any party to a construction contract to which the Act applies has a right to refer a matter to adjudication. And in the event that a party does not provide for adjudication in the contract, and that contract falls under the scope of the Act, then the provisions in the Act regarding adjudication will be applicable to that contract. So with or without you adding it in your contract, as long as your contract falls under the scope, you're going to be bound by adjudication as provided in the Act. The scheme for construction contracts is a subsidiary legislation to the Construction Act, and it comes in to fill the void left by the Act in certain respects with regard to things like time periods for notices and the like. It lists in detail the various provisions that are applicable to adjudication under a construction contract.
So is adjudication the initial dispute resolution mechanism under the Construction Act?
So ideally, yes. However, it should be noted that in the UK, there is a widespread use of JCT contracts.
Under the Act, when a party receives a payment application, what steps should be taken by the party and what's its effect when failing to take immediate next step?
The first thing that party should do is to examine that payment application and determine whether the amount in that application actually corresponds to the value of the work done. In the event that the paying party feels that it is not commensurate to the work done and does not agree with the amount stated in the application, the paying party must issue a pay less notice. The failure to issue a pay less notice in time is one of the key introductions in the Construction Act, and it is when you bring out the principle of pay now, argue later, or what is commonly referred to in the UK as smash and grab adjudication.
So in the adjudicator going about his adjudication adjudication process? Is he restricted just to the facts which have been presented before him?
Much as they have this leeway to dig deeper into the facts and the law, they must do it with the involvement of the parties. Under the FIDIC, the adjudicator has a right to withhold payment pending the payment of their fees. But when it comes to the Construction Act, there is no such provision.
Once you have clerical errors or grammatical errors or arithmetic errors, can these be corrected?
So under common law, there is the concept of the slip rule, where the judges correct grammatical and clerical errors in judgment. The same has been applied to the Construction Act.
Is it about time that we have a Construction Act in Uganda?
Yes, like yesterday.